Hi, my name is Marshall Casey, and I'm excited to talk to you today about Washington State's Constitution. I'm an attorney in Spokane, Washington. What's gotten me into this interesting item is I've recently been doing some cases that have more involved Washington State's Constitution, and I've started diving a little bit deeper into its history and its power. And as I've done that, I've realized that in our civil discourse and in our discussion in today's environment, we often talk about our constitutional rights, our federal constitution, and I hear things about the First Amendment, but I don't hear anything about Washington Constitution Article 1, Section 5. And so I sat there and thought, I'm not sure we all know enough about Washington's Constitution. So I want to start some videos that kind of walk through some things I've learned as we've gone along. And then I also hope to bring some people on where we can talk with them, not just about Washington's Constitution, but what does this mean in real life? And so we'll have some discussions, but I want to start off with kind of a discussion on what is Washington's Constitution? And probably the first question, I know you're here because you want to hear about this, but probably the first question is, why do you care? Well, I would say the first reason you should care about Washington's Constitution is reality. It is 95% of what you deal with government on day in and day out. You see, most of our lives, we don't deal with the federal government. Maybe when you board a plane, maybe at some times you'll deal with it. If you're mailing anything fraudulently, I guess that's a mail fraud. But most of the time, you are dealing with the roads you drive down, created by the government, come from the Washington State Constitution. The police, if you get pulled over for speeding or anything, their authority comes from the Washington State Constitution. You apply for a permit, it comes from the city that gets its authority from the Washington State Constitution or county. All these things we deal with day in and day out come from the Washington State Constitution. And the important thing is that is a sovereign power. It is a document that has founded a sovereign power. And so that is where many of your rights come from. As a matter of fact, in the recent years, since the 70s, people have a lot of scholars and judges have really started looking into the state constitutions to give them description of fundamental rights. And they've been seen as the state constitution is the untapped boundary of our fundamental individual liberties and the protections of those liberties. And so that's been a growing trend since the 70s and really been coming into the midst of our law and into a bunch of scholarship. So I think that's really key. What inspired me for this, though, was I've hit a few cases recently where I've found that, although there may be some federal protections for different people, the Washington State Constitution had so much more to say in protecting fundamental rights and individual liberties and people. And so that really inspired me to come on this road. So we are going to go through quite a few things as we go through the Washington State Constitution. I'm hoping we hit very soon on freedom of speech in the Washington State Constitution, because what you'll find is the federal First Amendment, and that's what we always talk about. It's here. But the Washington State freedom of speech, and you'll find that in Article 1, Section 5. We may talk a little bit about it today, but it's up here. It's higher. It gives you more protection than the First Amendment does, or broader protection, I should say. You'll find access to courts, separation of powers. Many of these things are different inside our Washington Constitution and more protecting. And so we'll talk through some of those different items as we go along. Freedom of speech. We'll do one on separation of powers, although that may not sound as important to you as freedom of speech. You'll be shocked. We'll talk about the Cloven decision, where it came out of when people could be released during COVID, prisoners. What kind of powers did the governor have? What kind of powers did the courts have? A way different view than in our federal constitution. We'll also talk about how different positions get their power. It is different under our federal versus our state constitution. And so we'll go through a lot of those. one of the ones that I'm looking forward to, because I don't know much about this, so I'm going to have to do a lot of research, and we may talk to some people who have, is what does the Washington Constitution have to say on the right to bear arms? We all see the Second Amendment, but do you often find what the Washington Constitution has to say on that? So we'll go through some fun things as we go. But today I wanted to really take you into really what's the difference between the Washington Constitution and the federal Constitution, because there is a dramatic difference between the two. And that dramatic difference will shape the way we look at these two different constitutions. Some of the things you have learned on the federal Constitution, we will need to treat a bit differently in the Washington Constitution. And one word of kind of warning here, although I am a lawyer and I'm taking you through this, none of this should be considered legal advice. We're exploring something here. And until the court comes out with a clear ruling on many things, sometimes that exploration is just that. We're exploring. So we're going to explore Washington's Constitution. But before we go, before we get into more of the details, let me take you through kind of the foundation of Washington's Constitution, how we got here, what are some of its differences between the federal. And one of the first things I want to address, and we'll get into in a moment, is the idea of sovereignty. You see, I remember doing some cases or some moot courts back in law school where we went over, I was in Vienna, and some other people from different countries were trying to quote US law. And it was funny, they'd always quote the federal law as if the federal law is higher than the state law. It's not necessarily. These are co-equal sovereigns, and they will work with each other. And there is a supremacy clause, and we'll talk a little bit about that. But these are sovereigns, okay? And the state is a sovereign, and the federal government is a sovereign. And we have two sovereigns in our lives because that actually, believe it or not, gives us more power. And we'll talk about that in a moment. But first, let's talk about where the idea of sovereignty comes from and where the idea of states comes from in our nation. I did a little PowerPoint, so let's start here. Okay, so when we look at back to the beginning of our nation and its founding, we had 13 colonies. We're all familiar with this, but the sovereignty was in the king. And so the king as a sovereign had all power. And while there may have been some limitations on it due to the British Constitution, generally he was considered the sovereign he's the fountain of justice. He is the one who can typically arrest people. There may have been some limitations, but he is also the one who can use legitimate force. And to me, the thing that most indicates whether or not someone has a sovereign power is whether or not they have legitimate use of violence. And what I mean by that, if I tell you someone is locked away inside a room, let's go with an 8x8 room, and they've been locked there for 5 years, your first question should be, who locked them there? Because if they've been locked there by the dude down the road, just locked in their basement for 5 years, we should be storming in there as a community to get that person out, because the dude down the road does not have legitimate use of violence. But if they've been locked there in a prison, and what I've just described to you is a prison cell, well, then they've been put away by the sovereign. And when we look at that, we say, well, that's probably a legitimate use of violence and force, locking them away. And so the difference for me on sovereignty, I find it really easy to boil down to this. When they use force and violence, do we consider it legitimate? And if the answer is yes, that most of the time we consider it legitimate. And there's times where, we'll talk about it's illegitimate because it's not the full sovereign using that power. And we'll get into that a little more. But if you look at it and say that's legitimate use of violence and force, well, then it's probably a sovereign who at the end of the day use that violence and force. And that's what sovereignty means. It's the fountain of justice. When it gives its decree, we consider it just. When it makes a law, we consider that law correct. And when the sovereign uses violence, we consider that violence correct. When it spends money, we consider it unquestionable, all those kind of things. Okay, so that's what sovereignty means. So at the beginning of the foundation of our country, the sovereignty was in the king, and it came down to the colonies. But what happened when we kicked the king out and decided he wasn't sovereign? Well, then the people became sovereign. We the people. And that's why the foundation of our federal constitution starts "We the people of the United States," because it was we the people granting power to the federal government. You may debate with me on that, but that is the general theory of most of the founding fathers. That is the theory that won the most votes, and why the Constitution we have is the Constitution. And then we the people also established states. Although they were many colonies and may have pre-existing the founding of the federal government, they were only empowered by we the people. And we will find that in the Washington Constitution, that is a powerful thing. So we now have two sovereigns, co-equal, one in the states and one in the federal government. So what are those differences? Well, the difference is the federal government has we the people, and you have the document, but it has an unlimited geographical scope. You will see that the federal government runs edge to edge and can go overseas. It's also what is the power that allows us to interact with other governments. It's an unlimited geographical boundary as a sovereign. That's the federal government. But the federal government only gets enumerated sovereign powers. You will find this in Article 1. It is an enumerated power. If Article 1 does not give the federal government that power, then the federal government lacks it. You'll find Article 3 has some powers as well in when federal courts come in. But if the Constitution does not give the government that power, then all those powers are reserved to the states. And actually, that is Amendment number 10 of our first Bill of Rights. So, and you'll find it, Amendment number 9 is those powers also being resolved or left with the people. So the federal government is unlimited geographical power, but only enumerated powers. So what do we do with the powers that, are not enumerated, or maybe even co? Well, those belong to the states. And what you're going to find is the states have limited geographical power, but plenary, so almost unlimited sovereign powers. They can do just about anything they please. Where they run into problems is if they conflict with the enumerated powers. And then there's some ways of working those out. But generally, states have unlimited power, but only within a very geographic limited area. So when our state was being founded, in 1889, we had a problem. And that problem, we're going to go through in a little history, but that problem was, how do we give these plenary powers to a government? Isn't that a little scary to give a government that much unlimited power? And so we'll talk through. So what they did was they devised our Constitution to only give the government almost I guess I would describe it best as a loaned power. So let's walk through a little bit of history that brings us up to the founding of our state, because that's going to show us kind of the problem that our founding fathers for the state of Washington had to deal with. Okay. So I'll take you back into the timeline. And I started this timeline running back to the 1600s and 1700s because sometimes we forget that much of our belief system started back in England and started back in probably when you had it goes back further. I could take you back into Magna Carta, but I think it's best if we start around the line of the Stuarts and the English Civil War. See, at that time, the Stuarts, they were a group of kings who had just come in, taken over for the Tudors, and they've come in from Scotland, and they come in with these ideas of divine right of kings and that the sovereign has no control. But when they come into England, many of the English are used to a parliament. They're used to an English constitution, maybe not fully written, but definitely developed in many areas, especially in the Magna Carta. And we'll even talk of the Magna Carta at some point on how it comes into our Constitution, because it does, it rolls through. But what's going down at that time is there's a lot of writers like Edward Coke, who's coming out, a lot of judges who are coming out trying to restrain these kings and saying, this is the law. And really, you see it in the judiciary before it gets into the parliament. You see it in the judiciary and the lawyers who are saying, these are our rights. Don't infringe upon our rights. And as that's going on, as the struggles are going on, that's when you start seeing America's colonies being founded. You have the Virginia colony, 1606, which comes over. People are starting to come over to that. Plymouth colony comes over. There's a lot of struggle going on about religious freedom at this time. You have the Massachusetts Bay colony going on. A lot of these foundations are coming in the midst of this struggle between a sovereign who thinks they have no limitations, okay? And we talked about what sovereignty is, and they think the king myself is sovereign without any input. And so there's a struggle. You've got the English Civil War, which comes over and says, you know what, we're going to have a struggle between Parliament and the king on which one of us is truly sovereign. And in 1639 to probably about the late mid 1640s, you have the fighting going on. You have the Commonwealth coming up where there is no king. And then you have the Restoration. And then ultimately you end with what's called the Glorious Revolution. And the reason I bring this out is you got to remember, as these things are happening, people are coming to America with these ideas. And in the Glorious Revolution, through the Hanoverian succession, what you have is you have the Parliament saying it is actually going to be appointing kings, and the Parliament, as the representatives of the nation and the people, voted in. And you can talk to me about their election being not fully democratic. It wasn't. But they're voted in, and they say, we have the power to appoint kings. We have that power. And you guys will follow us. And they begin to take some of the sovereignty away. And that is in the midst of the forming of our country. Those ideas are going on, back and forth, being developed. And our last colony is formed in 1733, which is the Georgia colony. Well, at that point, you have King George III. We all know about him. He comes to the throne, starts exercising more control as a king than his predecessors did. You have the French and Indian Wars that come over here. And all of that springs into the Revolutionary War. And it is built on the fact that we have ideas that are way different than England, even though they came from England. We've now developed these ideas as we go along, these ideas of individual liberty, these ideas that we are endowed by our Creator with certain inalienable rights, among those being life, liberty, and the pursuit of happiness. Those come through in the Revolutionary War. And from there, you roll into the US Constitution. Now, at this point, you have several states that have formed. All these states tend to have a Bill of Rights. And those bills of rights aren't necessarily in the US Constitution when it's formed. Instead, it is supposed to be enumerated powers, and that's enough. But they agree that we should probably have a Bill of Rights to extra protect the people from the federal government. And so the US Constitution comes in 1789. It's an important date because you'll see when our Constitution was formed. But then I want to put something else out here as we head into the 1800s. We are now a separate country. I've put kind of the American things at the top, or the full nation things at the top, and some of our Washington things at the bottom. I point out Marbury versus Madison as a case because this will come up later as we talk about some of these things. But at this point, the United States is coming up with an idea of what's called judicial review. Because in England, Parliament is the final say, final arbitrator on whether or not something is constitutional at this point. However, in the federal government, and many of the states, we come up with the courts are the final review of the constitutionality of a law. Whether or not a law meets our Constitution is in the federal courts. That's Marbury versus Madison, 1803. And that will become important as we get into such things as separation of powers, or when the Washington Constitution creates a right that's higher than the federal Constitution, because that has really been developed in our court system as we roll forward. But at that point, around 1830, you've got the Oregon Territory being settled, which Washington was a part of. You have in 1853, the Washington Territory is organized. At this point, you have the American Civil War and the railroads going across the West between 1869 to about 1900. And the reason I bring that up, this is very important that we remember, the railroads coming across the West is a big thought in the midst of our founders. Because one of the things that you will see in the Washington Constitution is we are what's called a progressive constitution. And don't interpret that like we interpret progressivism and conservatism at the time. The progressive movement back in the late 1900s or late 1800s, kind of into the early 1900s, that drove a lot of Teddy Roosevelt and the likes. And the goal of the progressive movement was, it wasn't as, they were very concerned about not just government power, but whether or not the government would be influenced by special lobbyists and special interest groups. And they didn't want that because they were concerned about corporations beginning to influence the government in certain ways and taking power away from the people. And we'll see that as we go through our Washington Constitution. That's not, you don't see that in the US Constitution, but because of the growth of the railroads, you'll see that in ours. And we'll talk more about that as we go through. But then in 1869, you have the Enabling Act of 4 states, and Washington is among those. And what that is Congress sets out, hey, listen, these states can be formed if they follow these rules. And there's an interesting one in the midst of the rules that we will get to as we talk along Washington's protection of freedom of religion, because we had to guarantee the protection of freedom of religion to become a state. And so the Enabling Act says, if you form a constitution and adopt it, well, then you can become a state. So also in 1889, oh, sorry, I left the Enabling Act with the wrong date. The Enabling Act was 1889. But also in 1889, the Washington Constitution was adopted. And that's an important thing to note, because over the course of 100 years of really this republic and a belief in democracy, rule of the people, individual rights and freedoms, that's where we've come about. The US Constitution, 1789, the Washington State Constitution is 1889. And many of our Bill of Rights did not necessarily come from the federal Constitution. We'll find that many of them come instead being borrowed from other constitutions, other state constitutions that predated the federal Constitution. And also, one of the things that I didn't quite put in there was in 1889, the federal Constitution was not really being enforced as the protector of liberties. So these people who are forming this plenary power are concerned. How do we protect the liberties of our people? So we've walked through a little bit of the history. I want to take you through some of the Constitution itself, because I want to show you some things that are different in the Washington Constitution from the federal Constitution. But so far, one of the things we've covered is the Washington Constitution is plenary power, limited geographical scope, but plenary power. How is that going to be divided between the people and the government? And they're dealing with this in the midst of a concern about railroads and special interests taking over their government. And that's an important thing to start with. So let's go into the Washington Constitution. And if you want to find this, there is a Washington Constitution on the in our legislature. The Washington legislature has a copy of this. That's where I pull it up from. Let me share a copy and we can all look over some key things. Okay, so this is Washington's Constitution. And I want to look at it real quickly with you on a few items, because this is an interesting piece of difference. And as I talk through this, I've highlighted actions that show you one of the key differences between Washington's Constitution and the federal Constitution, and that is Washington leaves a lot of the power with the people. And I almost describe it as the Constitution seems to lend power to the government and try and leave it with the people, versus the federal government is a grant from the people to the government. I mean, you look at it, it doesn't talk about the people reserving certain rights. They've granted these enumerated powers. In our Washington Constitution, time and time again, you will see it does not grant the same strength of, here you are, government. You don't need to come back to us. You got this power. No, in the Washington Constitution, everyone in government seems to be relatively close to needing to be elected and get power. So we start that scene in the Washington Constitution with the preamble. And this is way different than the federal preamble. We, the people of Washington State, you see right there, power comes from the people, grateful to the supreme ruler of the universe for our liberties, do ordain this Constitution. That's an important statement. It sees our liberties as not coming from the state, but from the supreme ruler of the universe. In other words, they're inherent in us. The state doesn't give them. They belong to us, really taken from the view of Locke. And it says, because of that gratefulness is why we ordain this Constitution. Take that and compare it to the federal Constitution. It's not to form a more perfect union. It's not to establish justice. It's not to ensure for domestic tranquility or the common defense. Instead, it's in gratefulness to the supreme ruler of the universe for our liberties. So our state constitution starts off, we're all here for liberty. And then you see it in Article 1. And one of the things I want you to look at in the difference between Article 1 in our Constitution, and you can go back and look at the federal Constitution, but the federal Constitution, remember how I talked of enumerated powers? The federal Constitution starts off with, here's Congress, and it has the enumerated powers of the following. Ours starts off with a Declaration of Rights. Now, remember, it's not creating the rights, but instead, I believe this Declaration of Rights is telling the government, here's the most important rights you are to protect. Here's the thing you are here for. And the first thing it starts off with is political power. Okay? All political power is inherent in the people. The governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. What a powerful statement that is. All political power remains inherent in the people. Okay? Didn't go to the government. We didn't hand it there. It remains in the people. And the governments are established with the consent of the governed, but mainly to protect. Well, actually, they are to protect and maintain individual rights. That's what our government exists to do. Now, it may do that by protecting you from your neighbor, by laying out some structures for us. It's not, hey, everyone runs roughshod. There is an ordered liberty that needs to happen, but it's there to maintain your individual rights through ordered liberty. You'll see in there that it says the United States Constitution is the supreme law of the land. The United States Constitution does provide for states, and it provides that every state is to have Republican form, and it does provide that the enumerated powers are not given to the federal government remain with the states, and that's where we get the plenary power. And there's a lot of other things that it rolls down, but one of the things, and we'll talk through some of these, you'll see right there, personal rights. You'll see the right to petition, assembly, freedom of speech. We'll go more into those. But I want to take you through a little bit more of the Constitution, because today, one of the key things I want you to take away is Washington's Constitution leaves power with the people and gives limited power to the government, almost on a borrowing type transaction is the way I interpret it. So if we roll down here, I've highlighted a few others. One of the interesting powers that we see in our state constitution, this is an interesting one because it comes up a lot. Section 33, one of the rights is to recall your elected officials. This does not exist at the federal level. At the state level, though, every elected public official, except for judges, is subject to recall by the voters. So every time we elect in an official, the people never surrender the rights enough to that people to not recall them. We have a fundamental right as a people to recall an official as long as we do it correctly and for a bunch of reasons. And we can go more through those reasons, but I think the important thing is, even in electing our officials, we never fully, as a people, surrender our entire rights to them. That's way different than the federal government. You cannot recall a congressperson. Can't be done. They're in there, they serve their term. There's ways of impeachment and removal, but those are not in the people. Okay. Then we get down into Article 2, the legislative department. So the legislative authority for the state of Washington, and I got to tell you, I don't fully appreciate enough of this. Something I intend to look into more, but the legislative powers are vested in the legislature, but the people reserve to themselves. So we're keeping this back to the people, reserves to themselves the power to propose bills and laws, to enact or reject the same at the polls, independent of the legislature, and also reserve the power at their own option to approve or reject at the polls any act, item, section, or part of any bill or act passed by the legislature. We have that power. And so in the midst of this, well, we've granted power to the legislature. We've kept it inside the people in the initiative process. Amazing thing. I find that purely fascinating. You don't see that in the federal Constitution. One of the other interesting things that you'll find is in the executive branch. Okay, remember we talked about the power to remove. One of the differences you'll see in Washington's Constitution is we are less trusting of government than the federal Constitution, because in the federal Constitution you have the president as the chief executive and basically making up the executive branch. I mean, although he can have officers in a cabinet, none of those are elected by the people. The president is the only elected executive officer. However, in Washington, we have several other elected officers who make up the executive department. We have the governor, we have the lieutenant governor, we've got the secretary of state, treasurer, auditor, all these other people who get elected directly from the people and then make up the executive department. Now, while the supreme executive power is invested with the governor, all those other people who he now has to work with as part of his executive department are elected by us. Just think of how much power that leaves to the people that the federal government doesn't leave with the people. And that's because Washington state is plenary. And so there's a deeper fear of handing too much power to the government in the midst of our Constitution. You'll see as well, interestingly enough, in the judiciary. Okay. This is a fascinating one and one of debate often. Our judiciary in Washington is an elected judiciary. Now, in the federal government, they're appointed. Here, though, our judiciary has to be accountable to the people. Everyone must get their power from the people in the election. Remember, all the government gets its power from the people. So we make our judges face election. Okay, every so many years they must face election. Many of you may know that I ran for the Court of Appeals. I didn't win it, but my opponent had to face election, and I had to face election. And so judges have to face election. And that is just more of a showing that everyone in Washington must be responsible at the end of the day to the people. And what a powerful statement. That's true of the Supreme Court. It's true of what we call our superior courts. Every one of them must face election. And we'll talk more about an interesting theory. One of our chief kind of developers of the idea of the Washington State Constitution, Justice Utter, or a developer as it being a protection of rights, Justice Utter gave an interesting thought on whether or not the fact that our elections allow for more judicial advocacy from the bench. I don't know. But his comment was, hey, listen, if there's more, if they face the election of the people, are they not more legitimate in judicial advocacy than the federal bench? That's an interesting conversation. I intend to bring a couple people in here to talk to them about that. I think that'd be a fascinating discussion going forward. Here's an interesting one. When you go to vote, just so you know, you're privileged from arrest, okay? You're also privileged from military duty that day. So that's something, you can be arrested for treason, felony, or breach of the peace. But outside of that, you're privileged from arrest. There's that privilege for legislators in here. I don't know if that's been developed well for voters, but that's a fascinating one to me. Again, voters, people are key here. Individual liberties, taking care of the people. That's what our government, the Washington Constitution makes that our government's chief overriding thing. Now, I highlighted in here something on the counties. We'll talk a little bit about this, but that's another thing. Counties, towns, they have direct constitutional power because, again, the Constitution was trying to give the people power. Even in a local area, you get power over your government. Okay, very important. And I'll round it up with just a couple other highlights, and we'll talk more. There's incorporation of municipalities. What they're saying there is our cities have a police power. They've got power direct, and it comes from the people. And so at the end of the day, one of the things that I wanted to make sure you understood here is the federal Constitution is way different on several key issues. And although we can use some of its principles, because remember, our founding fathers in 1889 had 100 years of experience with the federal code. That certainly went into their views. But what also went into their views was, we want to build a constitution that protects and maintains individual liberty. And we don't want a government with plenary power that can overwhelm. So I hope you join me for a few more. I'll try and keep some of these videos shorter and some longer. But the next one I think we're going to be doing is going to be around freedom of speech. It will probably be 2 videos. One of them where I'll be talking about the Washington Constitution on freedom of speech. I've done a lot of research on this recently, so I feel very comfortable going into it. And then I intend to bring in a couple speakers, see if I can find some people to come and talk to me on, some upcoming issues and where we think these will land on freedom of speech, because that's one that's coming. I will be trying to host a web page as well. I do have a blog out there, but I'm going to try and set up a system where You can email me, tell me if you have some thoughts that you want addressed as we go forward. Thank you for joining me on this journey, and I look forward to continuing it forward and looking more into our great Constitution in the wonderful state of Washington, with that almost now for, well, I guess almost 140, almost 150 years we are running on, and it's going to be, and it's been a good run so far. Okay, thank you.